Hello, everyone. Today, I wanted to talk about something that is very important. If you have lived in the United States without a legal status and you travel to your country of origin for your adjustment of status interview, did you know that you may be banned for re-entering the United States for 3 or 10 years? I'm going to talk about this today, and in a future video, I will talk about what you can do to protect yourself so you will be able to travel from United States and enter United States without worry. I'm Raluca Hanea. I work as an immigration attorney, estate planning, and family law. And my marketing and office manager, Nina Clear, is here with me. And all of your likes, shares, and comments help other people to see our videos. So thank you very much for them.
First, you had another success for a client recently, right?
Yes.
Can you tell us about that?
Yes, I had a client who came to me who had applied to remove the conditions on their green card, and instead of approval, they received a request for evidence. So I helped them to answer this request for evidence.
And to make it clear for people, you did not file their original adjustment of status application, right?
No, I didn't.
Do you think that them getting a request for evidence might have changed if you had?
Well, I always had, I have to, when I send a file for someone, I try to submit as much evidence as possible when I apply for my clients. So many times that will speed the process, so they will not get a request for evidence.
Can you remind people what the difference is between a request for evidence and an NOID?
Sure. Request for evidence. Okay, and let me go back. So an RFE, because that's how we call it, is a request for evidence. And this can be seen as a more positive notice than an NOID, which is a notice of intent to deny. So the request for evidence says, we think we will approve you, but we need more information from you to support that decision. But an NOID says we are planning to deny your application unless you can convince us otherwise.
Okay, and so what was the result for your current client?
After receiving the response for the RFE, along with my legal brief that I always include for my clients, they approved the adjustment of status for my client.
And it happened very quickly, didn't it?
Yes, very quickly. We sent our response in the middle of April, and we received the approval notice within the past few days.
So congratulations to you and to your client.
Thank you. And yes, congratulations to our client who, once they receive their permanent green card, will be a legal permanent resident.
And then based on the timing of their marriage and approval, since this was a marriage-based green card, they can apply for citizenship after 3 years, right?
That's right.
Okay, so now to today's topic. We recently had someone call our office, and they had a family member who had applied for them to get a green card. And their priority date was coming up, and the caller told us, well, they kind of more told us than asked, is it okay for them to travel to their home country for the interview? What would your response be?
I would tell them to talk to an attorney.
And why is that?
The biggest issue is if they leave United States, they may be banned from returning for from 3 to 10 years. And let me explain this in parts. So one, being given an interview in a consulate does not give you any type of legal status. Often people think, I got an interview, I can go to that country and come back in the US, but it's not that simple.
And why isn't it simple?
I need to repeat, people think that being given an interview time at the consulate gives them permission to leave and return to the US, but it does not.
And what does give them permission?
They must have a valid passport to travel, plus they must have legal authority that will allow them back to the US.
Can you explain about that a little bit more?
Sure. We have brought this up in different videos, but every time you want to enter the U.S. when you are not a U.S. citizen, you must pass through the borders and customs and are given an immigration review.
What does that mean, immigration review?
It means that the border or custom agent looks at their file and determine if they will be allowed in the U.S.
So having a letter stating that you have an interview scheduled at a foreign consulate is not permission.
No.
Okay, and what would be considered permission?
There are a few things. One would be if you have already a valid green card and a current stamp in your passport that indicates that, or you could have a current visa that gives you permission to enter the U.S. In the alternative, you could obtain emergency advance parole or advance parole.
And you also mentioned that people might be banned from entering. Is that true even if you have advance parole?
You may.
Can you tell us how?
Again, no matter what permission you have to enter legally, the borders or custom agent will review your file and make a decision at that time.
So what could cause you to be banned?
If you have lived in the United States without a legal status, by law, you may be banned from entering the United States for 3 to 10 years.
And that's a pretty big spread, 3 to 10 years.
Yes.
So what makes the difference?
If you lived in the United States for more than 180 days, but under 1 year without a legal status, you will be banned from entering the United States for 3 years. If you live in the United States without a legal status for over a year, you may be banned from entering the United States for 10 years.
And is there something that you could do to overcome either of those bans, the 3 or 10-year ban?
Yes, there are several types of waivers, and one specific to unlawful presence.
So it helps if you have had an unlawful presence, so you've been here without a legal status, that would make you ineligible to enter the U.S. That waiver does.
Right.
Okay, and can you tell us more about that?
Yes, I will, but not today. We're going to talk about that in another video this week.
Okay, so even though we're going to talk about it in another video, can you just tell us if you can travel before that waiver is approved?
No, you must wait until you have the approval.
And do you know how long that approval takes to get?
It depends on which processing center your application is at, but as of today, May 7, 2019, it looks like 7 to 11 months.
So do you recommend that someone applies for this as soon as possible or when they know their priority date is coming up?
I would recommend that they apply as soon as possible because even though the times are 7 to 11 months, if there is any additional information that is required, it might take longer. And we really want people to be aware if you have ever lived in the United States without a legal status, and that includes those who are here on DACA, do not travel outside the United States without a waiver or advance permission. So if you have any questions about it, please post them below and we will try to answer them in a video. Thank you again for your likes and comments, and we are always here to help. See you soon.